I will now turn it over to the presenters.
Thank you, Alicia, and good afternoon or good morning, depending on where you are in the country. My name is Rocio Molina. I'm the Deputy Director at the National Immigrant Women's Advocacy Project, and today our topic is on special immigrant juvenile status. We have invited Judge Ramona Gonzalez. She's a general court jurisdiction in La Crosse, Wisconsin, and she's also the president-elect of the National Council of Juvenile and Family Court Judges. She's been on the bench since 1995. Also joining her is Veronica Thronson. She is a clinical professor of law and director of the Michigan State University Law Clinic and Immigration Law Clinic. She is our expert that we work with on immigration law and family law, and she has particular expertise on special immigrant juvenile status. With that, I'll turn it over to you, Veronica.
Thank you, Rocio, and welcome, everyone. We are going to start today spending some time talking about special immigrant juvenile and also trying to go over how to get good orders that won't be rejected by the government. And so to start, I would like to ask you if we are going to start with the assumption that people already know a little bit of special immigrant juvenile status. We have a few slides that we are going to cover, but I think for us to spend more time doing the orders, we want to move rather quickly through the few slides at the beginning, and so hopefully you already have a little bit of experience. Otherwise, just please use your chat box so we can slow down or try to come back and cover other things that you may need along the way. So moving the slides, please. Thank you. So our objective is definitely making sure that people understand what the role of the state courts is when deciding special immigrant juvenile, and that's why we are very pleased to have Judge Gonzalez with us so she can give us her perspective from the bench. So this is a chart, and we are not going to be covering this whole chart, but this is a chart to show you how complicated special immigrant juvenile status can become, because it actually applies to so many children who may be in different statuses in the United States. It may be that the government is trying to deport them, or kids that the government is not aware of that they are in the United States. So it is complicated. That's the idea to tell you, right? Like, this is not a process that people can just say, oh, let me go apply and it's going to be something easy. And also, it's very important to keep in mind that we are dealing with children, and it's very, very difficult to deal with someone who may have suffered trauma as well. So these cases are not as simple as some people may want you to believe. So findings in a court. So for a child to be able to qualify for special immigrant juvenile, we need a state court, a juvenile court, to issue 3 special findings. One is that the child is going to be dependent on the juvenile court, that reunification with one or both of the kids' parents is not a viable option due to abuse, neglect, abandonment, or a similar basis under state law, and that it's not in the child's best interest to be sent back home. So what do we mean by that? A juvenile court is not, many people confuse it with what is a juvenile court. And the juvenile court is basically any state court that is going to be making determinations on where a child is going to spend the night. So for example, you have a dependency court or guardianship or family court that actually meets the definition of a juvenile court. Many judges get confused with that terminology because they think that we are talking about delinquency, but that is not the case. It's any court that is going to be determining custody and care of juveniles. Dependency, so it only means that a child is legally committed to or placed with someone. So if a judge issues an order for a child to be in a guardianship, then the child is dependent on the court. If the judge issues a decision on custody and child support, that also means that the child is dependent on the court. It doesn't mean that the court is going to be providing services to the child or the county is going to have to pay for the care of that child. It's only that the court has actually taken jurisdiction over the decision about this kid. So once the court accepts jurisdiction over deciding custody or guardianship, then the child is dependent on the court. And that is based on a case that came out many, many years ago, back in '94. And so placing a child in a guardianship situation, that means that the court has taken jurisdiction and that the child is dependent. Special Immigrant Juvenile and SIJS. Many people get confused thinking that the judges, by issuing the order, the judges are granting an immigration benefit to the child, and that is not the case. The only thing we need for a state court is to issue that order so a child can go to the federal government and try to get relief. And still, that's only one step in the process. Many times kids get an order from the judge, but maybe they don't qualify at the end, and maybe they get denied at the end. So the only thing that we need to make sure is that the court, the state court, is not going to be deciding the immigration case of the child. It's just one of the components that we are going to need to be able to help this kid along the way. Judge?
So at this point, we're talking about why are we involving family court members? Why are family court judges important in this process? So Congress had some very special goals that they wanted to meet, right? So they wanted, in this sense, back in the 1990s, they wanted to look at how do we address this humanitarian crisis of children born to help children living in the United States who had been abused, abandoned, or neglected. And so at least one of these parents has perpetrated the abandonment or neglect. So Congress then looked to the family court. Next slide. And so instead of creating a whole new system by which federal courts were going to be determining abuse, abandonment, and neglect, the Congress looked to those of us who already have that job. And in fact, we do that job every day. And so instead of creating these new special courts all across the country, they looked to family court state judges and said, here is a resource, a court that already takes into consideration adjudication of facts with regard to whether or not a child is abused, neglected, or abandoned. And what we're looking for is not for these judges to make a determination of granting status. What we're looking for is the factual basis by which we then, the department, can make those determinations. And so they are using the courts as the fact finders. And when we have fact finders, we issue orders. And those orders are about placement of children. And this can happen in all sorts of courts. So let's move on to the next slide and see if we can get our audience involved. We have you been involved with a case in which a court issues immigrant child special immigrant juvenile status findings? And you can make your votes, and we'll see, Veronica, how many of our audience has been involved in these cases.
Well, people are voting, but it seems to me that that most people have actually gotten, or maybe it's half and half,
Oh, see? The books continue.
Yeah. Okay,
Yes.
so good.
Okay, so I think we're about half and half, and I think what's really important for us as judges and those of you who practice in front of judges is to realize that this is really based on facts. We are the finders of facts, and we make conclusions about what is in the best interest of children, but DHS is looking for evidence. They're looking for us to be the fact finders on how this entire scheme of providing this relief goes. So it is not us, it is not state court judges awarding this status. It is the state court judges as part of the process in which the facts are determined to then allow the DHS to make those determinations. So that takes us to a fact scenario. So let's see how we can put into practice what we sort of just learned. And you can see this fact scenario is fairly long. So I will go along with it. Why don't we all read the facts of the case scenario, and when you're done reading, please raise your hand and we'll continue. And Rosario, you're monitoring the hand raising?
I just raised my hand to help too.
So did I. Well, we have 2 hands raised. We have some more hands raised. Okay. I think we're getting there. People are reading,
Yeah.
but they.
Yeah, we can get people just the gist, right? Like 2 kids, a not very nice person abusing them, Eduardo, and Clara is the mom, and then we have 2 kids, Miguel and Lupe, who were born in El Salvador.
And we have a lot of physical violence happening. The police arrest Eduardo for attempted murder and child abuse, take Clara to the hospital, and place the children in the care of the state. So, next slide. So what do you think? Would Lupe and Miguel qualify for status? And we have our vote. Oh, I think Veronica, we've got our answer to how well people know the subject.
Well, that was a very easy fact pattern, I have to say, right? Like the more complicated ones are the ones where you're like, oh, I don't know.
Okay, so we basically have the potentially eligible children. So the poll is closed. All right, let's move on to the next slide. There we go. So we're looking at these the children in our SAC scenario, right? We're looking at children who are abandoned, abused, or neglected, and it can happen either here in the United States or in their home country. But they have to be living with their non-abusive parent, guardian, adoptive parent, state foster care, or whatever. That means that they are in care. So they need to have protection from another parent. Next slide. So these are the kinds of decisions that we make every day, right? And I think this is what sometimes throws judges and maybe throws lawyers off. They see a potential immigration case and they want to try the case to immigration. And I would suggest to you that that's not really where the strength of the state court is. the state court's job every day in these kinds of cases is to make the determinations of where children should live and whether a child should be taken into care or whether a child needs to be placed with a better custodian than the child has at this time. Those are decisions that state court judges make, and it's important for when the cases are presented to state court that they're given in that vein. The emphasis of the reason for assuming the court's jurisdiction should not be seen just as determining the immigration status of a child. And for that case, though, and in that instance, these kinds of situations, these SIJS findings can be made in all sorts of cases. In any court in which the judge has jurisdiction to determine whether or not there's been abuse, neglect, or abandonment, and whether or not the placement of the child is in question. So it can happen in almost every other case, except for those cases in which the judge doesn't have any determination as to placement for children. And I think the one example in the Eduardo case above would be in the case of a criminal case. So it is really not about applying congressional law or federal law. It really is that Congress was looking for courts to do what courts do every day, to apply the state court law, to apply the state law with regard to abandonment and neglect and abuse, to establish, to do it by the book. Do you have jurisdiction? Does the court have jurisdiction under the jurisdictional mandates using the UCCJEA? And in those cases in which you're talking about somebody from out of the country, there's certain temporary emergency jurisdiction, and again, all those things such as notice and an opportunity to be heard have to be complied with. You have to look at the definitions of each individual state, because the court can only do what the court's inherent authority is, which is to apply the law in the state in which it sits. So the definitions of whether or not it's abuse, neglect, or abandonment are dependent upon the state law in the place that you are. And it doesn't require that there be some kind of formal criminal charge. Next slide. So you're looking more specifically to describe in your pleadings the actions of the facts. What is it that has been done that fits the definitions of abuse, neglect, or abandonment? And in that, the court makes those determinations, makes those factual determinations, but has to connect them to the definitions that the court has in its own state. And courts have to look to what the best interest law is in their state, whether it's statutory or whether it's case law. And sometimes you have to find this in the least anticipated places. So you sometimes can find this kind of information in the guardianship statutes where we talk about best interest for a minor. So next slide.
And here we have the different roles that people play, right? So we have the state court role and also DHS. And basically DHS is the one that is going to be adjudicating the case, reviewing evidence, making sure that the child is in fact a child, and making sure that this order was issued as part of protecting the child and that it wasn't brought in just for immigration purposes. Next slide.
All right, so we've given you the answer, but let's try another one. So when a state court issues SIJS findings, is the state court granting the child immigration relief? Let's see if we can get 100% participation on this one.
You can type in yes or no in the chat box.
Yay! I think we're getting that point across too, Veronica.
Yeah, that's good.
Okay, so let's move on then. Veronica, are we talking about what about if it's just one mom trying to get a leg up on her own immigration status?
Yeah, well, one of the things that is important to remember if you go back to the statute, right, like reunification with one or both parents. And so that means that every single adjudicator has agreed that the child could be perfectly fine living with one parent who is the non-abusive parent and still apply and qualify for special immigrant juvenile. Right? One of the things that is important to make sure that your state court judge knows is that the parent, the non-abusive parent, is never going to be able to get any benefit from the child's own special immigrant juvenile. So even if the child eventually becomes a U.S. citizen and he could actually petition for family members, he could never petition for a mom or for a dad. And so that is important. The benefit is only for that child because reunification with one or both parents was not viable due to the abuse, neglect, abandonment, or other situation of trauma and abuse.
So this is really a rhetorical question because what are the elements of a good SIJS court order? If you have an answer right now, you can put it in the chat box, but that's where we're moving to next. And that's what we have. Veronica?
So, yes, thank you. So here we have an actual order, and because I'm in Michigan, I'm giving you a Michigan order. And if you look at it, right, like it has the name, it was a guardianship case of a minor child, and then the court says I'm issuing the following special findings. And you have the three elements that you are required to submit, right, like the child has been declared dependent upon the juvenile court, the reunification is not possible, and it's not in the best interest of this child to be sent back home. And then the date and the signature of the judge, right? That's a pretty legitimate order, I would say.
I don't think so.
So let's talk about it.
I don't. You know, what do our audience think is missing from this lovely order that you have? Let's see if we get any responses. Citations to state law. Well, facts. Thank you. Thank you, Ashley. Yay. Yes. Detailed for the basis of the findings. Very good, Allison. Exactly.
Exactly. So if you have a judge giving you an order like this, and you file, right, like you have the three requisites, and you have you submit your package to DHS, chances are that a package is going to get rejected. DHS is going to say, we need more, right? And so we need more. Let's move on to the next one.
Yeah, and so we need more is why we're here today, right, Veronica?
Exactly.
All right.
So go ahead.
Okay, so you're looking at best practice. So as I indicated before, that previous order had absolutely no facts, no meat on the bones that we had. There was no nothing that the DHS could really touch to say this is what meets the standards under the statute. It's really interesting, Veronica. I think those are the kinds of orders that people do when they take it upon themselves to believe that what they're preparing is an order that has some import on the issue of immigration rather than a factual determination. What do you think?
And that is one of the things that DHS has told us, right? Like when they get a bare bone order that only has those three basic findings without anything else, then they are going to be questioning why is it that this child was brought within the jurisdiction of the court, right? There is absolutely nothing to say anything else about what happened to this kid, what happened to the parents. It's just that it's not possible to reunite them, right? And then it's not in his best interest. Like, we really need way more to make sure that the order is going to be sufficient.
And we have so much more ammunition now with the fact that a lot of our state courts are trained on the trauma impact on children and trying to really be more nuanced in how to connect the dots between what the parent's behavior is and what psychological and physical impact that has on the child. It really is, I think, a great opportunity to really provide in a factual basis and then some conclusions as to why, in fact, this order is in the best interest of the child. And it isn't just, oh, we want to get immigration status for this child, so we're just checking the boxes.
So we're going to cover the elements of a good order, and this slide covers jurisdiction, right? Like the judge is saying, right? Like the judge heard evidence, information was provided to him, right? Like he took testimony, right? And following the hearing, then the judge is issuing the order. The judge is describing the child, right? Like where the child is from, the date of birth, to make sure that they know that this is an unmarried child, right, under the laws of the state. And also that the court has jurisdiction to make determinations, right? Like this is an actual case, and this is a guardianship proceeding. And the judge is saying that he has legally placed this child with her legal guardian. So that's the jurisdictional element. That order is sufficient. The judge is using state law to let us know that he's following the right procedure. Viability of reunification. And here you have a little bit of facts, right? Like reunification with one or both of her parents is not viable. Then the judge addresses the mom. The mom neglected the child. She placed her with a woman to be a servant when she was a little kid, and there's the statute. The mother also abandoned her when she gave away custody of her and when she never attempted reunification. And then in this case, the father had passed away, so the judge just mentions, right, like the father is deceased. And that's enough, right? Like he's addressing both parents and explaining why is it that reunification with one or both of her parents is not a viable option for Jane.
So viability of reunification can be kind of tricky, though, Veronica, don't you think? Because most of the time people believe that that means that the other parent has no further parental rights on that child.
Exactly, and that is not the case. And as Judge Gonzalez mentioned earlier, there is no need to have formal charges filed against either parent. There's no requirement that you have a termination of parental rights action. You could actually have visitation with the other parent, right? Like the judge is going to say, I am granting physical custody to mom, for example, right? But if dad is around and he wants visits, then he can have visits with the child. And so definitely we have this to make sure that people aren't worried that, oh, if he visits the dad, then the order is not going to be good. No, no, no. It is perfectly legitimate as long as the judge is saying why is it that he's not giving custody to a dad, for example.
Well, and it's also really important, Veronica, in this case, for the judge to be real specific about the fact that it's going to we're not changing this later, because there has to be the granting of sole legal custody or physical custody to the abusive parent has to be out of the picture. I mean, I think there has to be a factual recognition that it is not in the best interest of this child to be reunited with his father or mother, the abusive parent. And that although visitation is in the best interest of the child, that the child residing with that parent is no longer a viable option.
Exactly.
So those are kind of tricky, but again, they're fact-specific, and they're fact-specific to the people in front of you, not just to general language.
Okay, and then the last section, right, the best interest. And so then the judge is describing why is it that the judge thinks that it's not in the best interest for Jane to go back to Haiti, right? And then he is saying what happened, that the child didn't have a safe, supportive, and stable life, right? Like she had basically been sold to be a servant. She was abused by the mom, right? The dad is dead. And now the judge is saying, and this child is now in a good, supportive family with the guardians. She's going to school. If she needs medical care, she's going to be receiving it. And that's why the judge is making his best interest determination, right? And remember that the best interest is basically the state statute, right? It's not like if I send this child back, this child is going to be tortured, right? It's not an asylum determination. It's only your basic standard, basic factors for best interest for the judge to make that decision on where the child is, that the child is better off being in the United States than being sent back home.
And I think judges sometimes do get into that that box of trying to determine whether it should be an asylum. And it's really important for advocates to clarify that is not the issue before the court. So when you're preparing your case or when you're preparing your decision, we included this slide with these factors because it's really important that you consider these as the general factors, but connect the dots for DHS on what are the facts that support each of these factors. When you're looking at the risk of danger to the child, it can't just be simply a statement of danger. It has to be a conclusion supported by evidence. And if you can't, this is where some judges get sort of in a tizzy because they're like, well, how am I supposed to find facts about something that happened, outside of the United States? Who am I to know? That's ridiculous. I can't do that. And my answer to that is we do every day in our courts across the country make determinations of facts of things that happened in another state. And we do it, or in another town, or in another school, and we do it based upon the credibility of the evidence presented to us. And this really is no different. Don't you think, Veronica? Because I think we could get ourselves really tied up in not thinking about it being, I wasn't there, so I can't make findings.
Well, exactly, and it is, the idea is to make it as easy as possible for your state court judge, right? Like there are judges who get pretty frustrated when people come into the courtroom and are asking them to issue the findings without giving them enough information to make a decision, right? And so a judge could say, I really couldn't do this. How do I know, right? Like you are not doing a good job of telling me exactly what happened, or you don't have an affidavit from a child or from a mom if the mom is around, or from the guardians, right? Like you need to be able to give the judge enough information to make sure that it's easy for that judge to issue that decision and give you the order.
And it's also one of those times where you have to be creative on how you present the evidence, right? Some judges, some courts are hesitant to have electronic evidence, but this is, I think, a place where you could use Skype testimony from a relative in a different country. What do you think about that, Veronica?
That actually is helpful sometimes, and one of the things that the judge needs to be aware as well is that he is not being tasked with trying to find any placement in home country, right? Like Okay, so let's say mom is back in El Salvador, for example, right? Is the judge going to say, why is it that mom is not able to take care of this child, right? And let's say the judge determines that mom is not a good caretaker for the kid to go back. Okay, let's look for another cousin in El Salvador maybe, right? That is not really the judge's job, right? The judge is going to say, what is in the best interest of this child? And many times, in so many cases, maybe the best thing is for the child to go back home, right? So it doesn't mean that you are going to win every single case, but you should make sure that the judge has enough evidence to make that determination. I remember I had a case where the client, the parents were back in Guatemala, and the child was with her sister here in the United States. And the child was constantly communicating with parents. She was a teenager, and the judge said, you know what? I think it's in her best interest to go back. Like, she has enough communication with her parents. Like, I don't see why she couldn't go back. The parents sound lovely. And we were like, that's not really the outcome we wanted. But the judge really didn't think that that it wasn't in her best interest to remain here, because the parents were, she kept in constant communication with the parents. They were together. There wasn't any issue with abuse. Our claim was that the dad had neglected her by crossing the border with her, and then dad immediately got deported, and the child stayed behind, and then the child ended up going back. She didn't want to, but that was the outcome. And the judge said, I'll give you 2 out of your 3 findings. And we were like, we need 3, otherwise don't bother with giving me 2 findings, right? Like, that would not help me at all. And so, it's going to be a case sometimes maybe when, yes, you want to help your client, and you want to make sure your client gets that green card at the end of the day. But, many times being with a mom or with a dad is way better than a green card.
Right. And that just goes to show that that's exactly what judges are supposed to do. They're supposed to look at the facts. They're supposed to make the determinations based upon their state law. And in those kinds of situations, you wouldn't certainly find that it would not be viable to reunite a child with parents if the situation was that communication was happening in the United States, right? If that was happening in the United States between 2 different states, and the child is here, we're not going to make a find that it's not viable to reunite that family and that child. One of the other factors that's listed on our slide is really an interesting one I haven't seen used, Veronica, maybe you have, and that is the presumption that a perpetrator of domestic violence it should not be the custodian of a child.
So, so there are judges who say, it is domestic violence is going to be a factor in deciding custody. Right? There are some states that do that. And many times abusers end up with custody of kids. And so I wouldn't say that's a given. I think it's based on what the attorneys are going to be submitting to the state court judge to make sure that the judge has enough information and is convinced that the information is convincing enough for that judge. I have had cases where I asked the judge to give me an evidentiary hearing, right? When I see that the judge is trying to, either do joint custody or, like, oh, this was many years ago, or he never abused the child, right? Like stuff like that. And so I'm like, give me an opportunity to brief this, to tell you how witnessing domestic violence has an impact and has traumatizing, issues for the child, right? Like, give me a chance to brief it and then see if I can actually change your mind. But there are judges who are readily ready to be sending the kids to an abuser.
Yeah, so when you apply those factors then, Veronica, are you looking to determine whether or not it's in the best interest of the child to return to a home country, which takes us to the next slide?
Many times that could be the case, right? And so as I said before, it's not an asylum determination. So many times the judge wants to make sure, right? Like, was the kid, and a lot of the kids, particularly from Central America, right? Like they quit school at, third grade and then they started working, or, they were not being going to school, right? I have had so many clients who didn't know how to read or how to write, and because they were just working as soon as they were, like 7 years old, right? And so what is the education they are going to get in the United States? Do they have access to medical care? Do they have access to the education, right? Like what other opportunities would they have than that they wouldn't have in their country of origin if they were sent back? Right, and so that's something that the judge is going to be looking at, and it's not that, oh, he's going to be tortured or the abuser is back home, right? Although, of course, that's an element, but the judge is going to want to make sure that the future for the child is going to be better here.
So does the court have to go through each one of those placements individually, you think, and give the factual determinations of each placement?
It depends on what type of placement, right? If the child was being raised, I don't know, by grandma back in El Salvador and parents are in the United States, right? Like, is the child going to say the child is better? Is the judge going to say the child is better off going back to grandma, right, if the parents are here? Right, and so those are the things that it's all fact specific, right? Like what facts are you giving the judge? What is the story of this child? How did the child come here? Right, many times the parents are the ones who are paying the smuggler for the child to come and reunite with them in the United States. And so, like many times the ORR, the Office of Refugee Resettlement, may not even want to place that kid with a parent, right, if they know that there was neglect or there was abuse, right? But the judge is going to want to know, but they aren't going to go back to every single relative who is back home, because who is going to say, oh, I'm going to be responsible for this kid, just send him back.
Right. So when a litigant, when an advocate or a lawyer is presenting this case to a court, is there sort of a fine line that they're walking between being able to provide this information and making it look patently obvious that what we're looking for is an order that will grant the DHS the opportunity to give immigration status? Because I would think that you have to be really careful about how you draft that.
You have to be very careful, and you, as a judge deciding these cases, you know what you want to see, right? If someone is bringing you in a child who's going to turn 18 next week, for example, and they are asking you to make the special findings for them, like what evidence are you going to be asking them, right? Like, why is it that you need me to issue an order when this kid is going to a child next week? Right, I mean, I'm exaggerating, but I'm sure there are cases like that, right? Like, why is it that you want me to give this person guardianship over this kid who's going to a child, right? And so you may be suspicious of cases like that, because you're going to say, wait, he's going to be 18 next week, so why does he need a guardian for 1 week? And then the advocate or the attorney is going to have to explain to you, right? Like, why is it that they are seeking that order? Because it cannot be done for immigration purposes only.
Exactly, and I think that's probably one of the biggest pitfalls for these cases is child welfare agencies who wait to the last minute, who don't think about the consequences for their kids in their care until it's too late. I almost think that every child welfare agency who has a child, I think that should be on their intake question as to what the origin of the child is, so they can start thinking about these issues early on.
And that is how SIJS came to be, actually. It was the foster care workers in California who were releasing kids and then realizing that the kids didn't have any papers. Right, that is how SIJS started. And so when you have a state worker, when you have CPS involved, those cases are actually much better for DHS because they know that there is a legitimate state interest for having brought this kid within the jurisdiction of the court. Right? I think when DHS becomes a little bit suspicious is when a parent or a cousin is trying to bring an action for a child who's going to age out pretty soon.
And I think this is sort of a lost opportunity for child welfare agencies and the courts. I know of at least one judge in Nebraska who's appointing a immigration lawyer to children and child in need of protection or services cases to investigate whether or not there's an issue that needs to be addressed when the case first comes into court.
Well, that would be a very good idea for many of these cases, right? Because many times the people come, they get the order from the state court, and then they never come back. Like in Michigan, the judges would actually have, after issuing the order, they want a status hearing. They want you to come back, 6 months from now, 9 months from now, to know exactly what's going on, to make sure, right, that they really didn't just come to get the order and then disappear.
Yeah, it seems to me, Veronica, this is a lot of work for advocates to make sure that that the lawyers get the information to the judge, and then to make sure that the judge articulates the reasons in their orders. So have you done proposed
and it
orders?
goes back to things that we should try to train attorneys and advocates, right, to make sure that the judges are issuing good, solid orders that are not going to be questioned by DHS.
Yeah. Have you run across judges who refuse proposed orders, proposed findings of facts and conclusions of law and orders?
Yes, many times the judges have, many jurisdictions use form orders where they just check the box. And so in many of those cases, we ask them if they could sign an additional order, right, in addition to the form order they have to use. And so we submit a proposed order with our motion. And then are ready to see many times, like I have had judges who say, I'm not a juvenile court. I don't want you to say juvenile court in your proposed order. And then I say, how about I say this court? And they said, sure. And then I fix it, right? And so, so I bring different versions, especially when I don't know the judges, right? And so, and then they sign it. But so form orders are some, and many times you may need to submit your motion to DHS. They may want to see what else did you provide to the court for the judge to issue the order. And that's why it's important that the judge uses the facts and uses correct citations to make sure that DHS knows that there was a legitimate reason why this child was brought within this jurisdiction.
Yes, I would say as a judge looking at this slide, making those findings in number 4, I think might be the biggest challenge. Can you give me an example?
So
making findings that illustrate why. Yeah.
So it would be, it depends on who's bringing the action, right? Let's say it's a divorce action and mom fled the jurisdiction. Let's say mom fled Guatemala with the kid and dad is back home, right? And then she's trying to get a divorce from husband and then trying to get custody, and in addition to custody, she wants the special findings. Right, and so, what is mom's testimony going to be, right? Was she a victim of abuse, or did he abandon the kids, or did he neglect them, right? Like the judge is going to want to know more information on that case, right? Like just to issue a custody order, let alone the special findings. And so if depending on the facts, right? Like if the dad was an amazing father and mom just decided to leave because she had an extra boyfriend in the United States, right? That is going to come out as the judge is taking evidence, right? As they are doing a hearing. So it could be that the judge says, well, for now, I'm going to give you temporary custody until we give dad the opportunity to appear, and many times they appear telephonically, right? And chances are the judge in a case like that, where the dad could be like, she fled with my kid, I really want my kid, right? Like they could then get Hague involved, depending on what country that is, right? And so the dad could actually have a claim for the kid to be back home under Hague. And so there are different factors, and it's all going to be very case specific.
Yeah, and I think to close out the slide, I think the question I have is always why. If somebody reads my order or reads my decision and they're still asking why did the judge do that, then I have failed to write an appropriate order.
Exactly. Yeah, maybe you didn't have enough information, right, to explain exactly why.
Right, because if you read it and the question is still why are you choosing not to place the child in the child's home country, then that's a failed order. You have to have the factual underpinnings to put and the connecting the dots between those factual underpinnings and the state court law with regard to best interest to be able to have a viable order.
Exactly.
So let's, oops, where are we? So we're back at our scenario. So in the case of Clara and Eduardo scenario, in which of the following cases could the court not issue the orders that we've been talking about here? See if we got answers here. Everybody vote, please. Yay! I gave the answer early on, didn't I, Veronica?
You did. You did.
I was trying to be nice, trying to give them the facts to be able to make their determination. But I think everyone is on board with that. So, Alicia, I think we're done with the polls. So yeah, so the one place where a judge is not going to be making a determination as to placement in best interest of the child is that criminal prosecution of Eduardo. But in all those other cases, clearly a judge could make the appropriate findings provided that the evidence is given to them in court and the facts are laid out. And quite frankly, as a judge, I just want to say that sometimes just laying out the facts for a judge are not enough. You have to actually, in your argument, then connect the dots, because that's really where advocacy is most important. Being a good advocate can take facts and paint them in a way to sway the judge to your way. And this is a place where we really need good advocacy to be able to connect the dots for the judge, who then provides an order that connects the dots that then can go to DHS, who easily can see that the judge's decision was appropriate.
Exactly.
Okay, so what do we think about issues to avoid when we draft these orders, Veronica?
Yeah, so why don't we ask people, maybe you could start typing in the chat box, like what should be, from learning today or from knowledge that you may have had prior to this webinar, what should we be avoiding in a court order?
Let's see, are we getting any answers? Any citation to federal immigration law?
That's a good one.
That is a great one.
Very good, right? Like I'm asking for SIJ because immigration, right? Yeah.
And whether the child is eligible for immigration benefit. Yeah, we don't want that in there either.
Exactly, exactly.
Lack of citations from state authorities. Very true. having the definition of abuse, neglect, and having those cited by state statute are extremely important. And any factors that are determined of best practice, of best interest, are best practice to put in those orders as well.
How about another thing is that sometimes people want to give the judge too much. I have had cases that I have reviewed where they write about all of the gang activity of the kid in home country, right? Like, that's going to be an issue for immigration, but the state court judge, does he really need to know, right, that the kid was a gang member, for example? Like we had a jurisdiction in one county here in Michigan, and the judge would actually ask the kid, every child, different questions related to gang affiliation. And if he even suspected that the kid had been involved in some way, he would just not give the order.
Oh, wow.
So many times people add a lot. Like I saw a case where the kid had been kidnapped by the Zetas in Mexico, and the advocate wrote, he was trained to use a rifle when he was working for the Zetas. And I'm like, he wasn't working for them. He was kidnapped. And so, right, there is a lot of information sometimes that the state court judge doesn't really need to know. It's not that you're hiding the ball, but there are facts that are not really relevant to what you are asking the judge to give you, right? Like you want the judge to issue you want the judge to issue something that is going to protect the kid, and all of this additional information could just confuse the judge, and then the judge is going to be, questioning more or asking you to provide more, and then forgetting what the role was, right? Like what was the point of appearing in family court or juvenile court.
Right. And, Ashley just added another important one, the immigration statuses of parents or guardians. I've always told my cases, listen, somebody wants to argue to me about why the immigration status of a custodian is important, because they say, well, they could be deported next week, Judge. And I said, well, yeah, but they could also be hit by a bus walking out of the courthouse. What is the difference? I'm not going to consider either one of those alternatives.
Yeah.
So basically, that's not an issue for the determination that I would be making.
Well, and Ashley is right, too, that many parents or guardians who don't have lawful immigration status may be concerned about appearing in court, right? Like they could say, what if I go to court and then ICE is going to pick me up? And those are definitely legitimate concerns that people should be aware of. And, you cannot really tell people, oh, don't worry, 100% this is not going to happen. But you also need to know your jurisdiction, right? Like you definitely don't want to jeopardize the safety of your clients by bringing them to court.
Right. Well, it looks like everybody covered a lot of what we fleshed out before. That detail and facts that you just highlighted can be a two-edged sword, but the order has to be based on facts. Oh.
Yeah, Andrea is asking if anyone has seen detention for guardians who are undocumented. I haven't, but I'm in Michigan, and we have 83 different counties, and the counties where I practice, I haven't seen it. And I have had guardians who are undocumented, but I don't know if other people have had different experiences.
I haven't seen it in La Crosse in Wisconsin, but I haven't seen a lot of things that I've suddenly seen in the last 2 years. So it's a distinct possibility.
Yeah, and that's going to be important when people are doing intake, right? Like asking the potential guardians or asking the custodians, right? Like, do you have any immigration history, right? Do you have any order of deportation that maybe you just didn't go, or have you been in front of an immigration judge, right? Like many times, those basic questions would help a lot in trying to protect the client and trying to protect the kids as well.
Can we have the next slide, Rocio? Because I think we have come to the end of our hour, and I want to make sure that people know our resources, right?
Yes.
So
go ahead.
I think we are. I just wanted to cover what Ashley said. So the only ones who get fingerprinted for the I-360 are the kids, the applicants. And some jurisdictions require a guardian to provide fingerprints for the state court action. So you need to know your jurisdiction. And I think ORR, to release a kid to a sponsor, I think in some cases they are skipping the fingerprinting because they are overcrowded at the border. And so they are trying to place the kids quickly with sponsors.
Okay, well, while the other question is coming in, we have developed a web page for this webinar, and the materials including the PowerPoint are available. Once the recording is available, we'll also post that as well. And that includes a bench book on a special immigrant juvenile status, a U-Visa certification toolkit for judges, and several bench cards for family court judges. It also has a link to our state-by-state directory of programs that have experience working with immigrant victims. As a technical assistance provider, we're here to be a resource for you, and we will connect you with experts that might have more knowledge on that particular topic. So please do reach out to us. You can call us at 202-274-4457 or email us at info@nuap.org. There's also a web library where you can search among all the special immigrant juvenile status or other immigration remedies or multiple subjects that might be of interest to you. So please come to us for resources, and we can connect you with information at a deeper level on this subject.
And thank you, everyone, for your attention today. It's been a joy.
And feel free to reach out even if you have other issues. This technical assistance email gets to us as well. And if people need sample motions or samples of well-drafted orders, please reach out and we'll be able to help you.
Thank you, Veronica, and thank you, Judge Gonzalez, for sharing your knowledge on this very important and unique immigration remedy that protects vulnerable youth.
Thank you,
thank
everyone.
you, Counsel.
Mm-hmm.